from the government in just about a year on the substance of those issues, and that is part of the problem.
I call the honourable member Keith Locke.
Thank you, Mr. Speaker. This is one of the worst bills to pass through this Parliament, and it's being rushed through completely unnecessarily, and is a retrospective bill that legalises illegal behaviour by the police and other agencies. This Parliament is here to make laws, and people are punished for breaking those laws. In this case, we're doing the very opposite. Parliament has found that the police and people in other state agencies, and the bill does talk about other state agencies, it's important to know that this isn't just about the police, it's about other state agencies that have search powers as well. And we have found that the police have been breaking the law by engaging in covert video surveillance without authority. And rather than bringing the police to account or some sort of punishment, what are we doing? We're passing a law in a rush to make this illegal behaviour legal. Way back to the time that video cameras were invented, there's no start date to this bill, and for a year into the future. And I think the essence of this is that we're overriding one of the most important laws on our statute books, that is the Bill of Rights. The Bill of Rights has a section 21 which protects the public from unreasonable search and seizure by state agencies, including unreasonable surveillance. And Chief Justice Sean Alliance, in her 2 September judgment, explained this. She said that covert surveillance by the police of people who do not know that they're being observed collides with the values of freedom and dignity in the same way that the search of their correspondence or interception of their conversations. The right to be secure against unreasonable search underscores a purpose in allowing citizens to relax vigilance and live their lives with freedom. And that is what the highest judicial officer in the land says. And she makes clear in her judgment that the police and other agencies are only able to do such covert video surveillance in breach of the Bill of Rights with lawful authority. And there's been a lot of talk here about how we didn't know that the police were doing wrong. Well, the judgment of Sean Alliance says the opposite. She talks about the deliberate breaking of the law by the police in this case, and she uses that word deliberate. She says, quote, "In circumstances where the police officer in charge of the inquiry knew that there was no authority for such film surveillance, the deliberate unlawfulness of the police conduct in covert filming, maintained over many entries and over a period of some 10 months, is destructive of an effective and credible system of justice," end quote. She's not pulling punches at all there. And this idea that we all thought it was part of the common law is rubbish. It is wrong, because even just in recent times we know that the Law Commission, in its report on search and surveillance, laid out very clearly that there wasn't lawful authority for covert video surveillance. They highlighted that, and from that point on, every police officer, every state agency would have known that they were breaking the law. Then there was the High Court decision in the Operation 8 case, 7th October 2009, which specifically said that it was unlawful to conduct video surveillance, and that was what that case was about. Of course, the decision used Section 30 of the Evidence Act and said, despite it being unlawfully collected, we will accept it because it's pretty serious crimes we're talking about. That was their decision. So from that High Court decision, or at least from that High Court decision in 7th October 2009, until after a year, it was over a year later that the Court of Appeal came down with its judgment on 17th November 2010. Now, the police should have been absolutely instructed to cease video surveillance, and they knew, and that is why Sean Elias, Chief Justice, said that they were deliberately breaking the law, that they knew of that High Court decision, they knew of other decisions like the Gardner decision, and they consciously broke the law. This bill here provides for almost all video surveillance except video surveillance, covert video surveillance involving trespass. But it does allow, for example, sticking a video camera on a building next door to a place that you want to spy on, or the police or some other state agency wants to spy on, and the person inside the backyard or the bedroom or the living room that is being spied upon and doesn't know they're being spied upon, and if it's on a high place they wouldn't expect that they were being spied upon, their Bill of Rights guarantee against unreasonable search and surveillance is very much violated. They would be expecting privacy. And as I said, this doesn't just apply to the police, it applies to any agency with warranted search powers, which can include the Commerce Department, the Conservation Department, the Customs, Internal Affairs, Food Safety Authority, to name a few. These are all given carte blanche for all past video surveillance and any future surveillance for a year. Why is this bill being rushed? That's what we want to know. It is very rushed. We didn't even get a copy of this bill until the first speaker, the Attorney General, started his speech, and it's impossible to have a proper process when speakers in the first reading only have a few minutes virtually to absorb the bill, and because it's important with the first reading to give the public and any submitters to a select committee process a bit of a steer by the different parties putting into their considered views, which hasn't been able to happen in this case. And now I understand, I've heard that there's going to be a select committee tomorrow morning at 9 o'clock. Somebody said, I don't know whether that's the case or not, but it's going to be, by reports, a very rushed process. And particularly groups, voluntary groups like New Zealand Council for Civil Liberties or Human Rights Foundation, or any groups like that haven't got full-time staff and are not full-time lawyers, etc., to really contribute to such a rushed select committee, and that is important if we're to get a right determination here. Now, why is there all of this rush? Wouldn't it be much easier to just wait until the next Parliament, a month or two down the track, and debate this and pass the search and surveillance bill? The Green Party would support giving priority to that bill. And it's important because complex issues involved here, which is why the Justice and Electoral Select Committee, upon which I sat for the Green Party for this bill, spent 2 years discussing all this complex constraints and procedures around search and surveillance. And then, since then, the bill has been waiting in the parliamentary hopper for the second reading. And when we discussed the bill in the Select Committee, we actually went back, unusually for any bill, we went back to submitters for a second round because we wanted to get it right, and it was very complicated. And the Greens think there's a lot of good things in that search and surveillance bill, although we're critical of some elements of it, which is why we haven't been supporting it as a whole. We don't want a provision in there for covert video surveillance involving trespass. We're very much against that. Now, what is the argument for haste? That there are 40 current trials and 50 police investigations that might be compromised, but, you know, are we really sure about those figures? I asked the question today about how many trials involved this form of surveillance in trials that are completed just this last year, and I wasn't given a figure at all. It was too hard to even work out a figure, apparently. So I don't necessarily trust that figure of 40 trials and 50 police investigations, and there's two other things, in that most trials and investigations involve a lot of other evidence. How do we know that the covert video evidence is critical? And in any case, there's the Evidence Act, Section 30, which allows illegally obtained evidence to be accepted in the court case if the case is serious enough. So I don't see that more than one or two criminals would get off if we just left it a month or two until the next Parliament, and that can be the price of civil liberties. The price of civil liberties is that you have to have that some criminals actually get off. That is the price of civil liberties, and always talking about here as a temporary period. Now, I think it's important, when you think back years ago, there's a whole tradition in the protection of privacy, and I think one good quote perhaps to finish on is one from Prime Minister William Pitt, or Pitt the Elder, who said, quote, "The poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter." And I think the essence of that is we should very jealously protect our privacy from unreasonable surveillance by state forces. Thank you.
I acknowledge the Honourable Minister Rodney Hyde.
Thank you, Mr.